Okay, if I pushed all the buttons correctly, we should be live on YouTube, on Rumble, on Locals, and on X. How's everybody doing?
Looks like it's working.
It's all right.
Doing well.
I'm doing good.
All right, good deal. Now, I know Dave can't be here the whole show, so I want to move him up the line. You wanted to talk about the brand new Turtleboy case.
The Turtleboy case. Yes, it sounds silly. And so I saw this pop up the other day, Wednesday. And I'm like, what's this Turtleboy thing? So Turtleboy is apparently a blogger. That's not his real name, obviously. And he's also a YouTuber. But he's been covering the Karen Reed case. Apparently he's local. This is in Canton, Massachusetts. Karen Reed, if you don't know, has been charged in the killing of her boyfriend, who's also a police officer. There's a lot of weird things going on around there. And a lot of people, including the defense, are bringing up the fact that she's essentially being framed for this. That had something to do with perhaps a dog owned by one of the other officers. That it was like a house party, and he ended up dead outside of it in the snow. So
say what the initial charges were. She supposedly ran him down with her vehicle and didn't know about it, correct? Like backed over him or something. They found a tail light and remnants, and then something about her cocktail glass was embedded in the bumper, which I thought was a weird statement.
And there's a lot of weird things, like supposedly the broken glass from the taillight was discovered on the floor in like the exam room or the hospital room, and it's like, well, that wouldn't have been, and so they're wondering if that was planted. And the kind of the rumor is that it might have been some sort of accident with one of the other guy's dog, who happened to, just weeks later be, sent to a farm, right? Where dogs go to retire. The house that this took place at was sold right away after a couple of renovations that were fairly quickly done, that didn't seem to be planned in advance. There's a lot of weird things going on. So Turtleboy News is a blogger. He's also has a YouTube channel, and he's been covering this, and he's been pulling down, like we all do, public documents, indictments, the exhibits that are available, and things like that. And he's been talking about the case. Well, he's also been trying to investigate this, because there's a lot of things that don't line up. You have one police officer that says, I don't know these particular people, even though there's a photograph apparently of them hanging out, at a family event with these people 2 years prior. There's a lot of weird inconsistencies between the police statements and what other evidence is showing. The lead detective, apparently, it looks like, he said he didn't know, the parties involved, the victim or the defendant or anything like that. Yet there's other evidence that suggests that he did. So while he's going through these public documents, he's recognizing, or he sees phone numbers. So he starts calling these phone numbers. These are the police officers' cell phones, but work cell phones. It's not their private cell phone. And he's leaving them messages. Or he'll go to a sporting event where some of these police officers are there, and he'll ask them questions. Or when they're going into court, there was a video they showed him standing outside in a suit and tie with his phone up, recording and trying to ask people questions, as an investigative reporter does. Apparently the police officers didn't like it, but it's not just the police officers. He is calling their wives, but they were also witnesses to the case and are making inconsistent statements too. So he's calling them and asking them questions, much like an investigative reporter does. Now he does it very kind of tongue in cheek. It's funny. All right. It's almost kind of like a cross between an investigative reporter and like a shock jock kind of thing. But he's got good questions that he leaves, voicemails for and things like that. And so apparently the other day, earlier this week, some of the police officers and maybe their wives tried to get like a personal protection order against him, and that failed. And then just Wednesday, he was charged and arraigned on witness intimidation charges for attempting to intimidate these witnesses. That's the allegation. So that whatever, it wasn't really clear on what the nature of the intimidation was, or what he was actually trying to get the witnesses to do, change their testimony or whatever, not testify. But he was charged on witness intimidation grounds. But I don't like the Massachusetts statute, because we all get the idea behind witness intimidation. Hey, I'll give you, $2,000, you don't testify. Or if you testify this way, then you or your family's in danger, right? That's the idea behind it. Mm-hmm. Not asking for any of that. That's not been alleged. He's been alleged to leave harassing messages, and he has them recorded on his YouTube channel. The prosecutor specifically brought up episode 590, episode 617, and episode 598. So I went back and watched those on Rumble last Wednesday. And again, he's just calling with legitimate questions. Like, hey, you say in this report that you don't know these people, yet we have a picture of you from like 2 years ago that says you do. Can you explain that, please? And all kinds of things like that. And so I don't think it rises to that level. But the issue I have with the statute, the prosecutor read it aloud during the arraignment, is that it says communicate, blah, 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 all the bells and whistles, with the intent of, with reckless disregard of harassing, intimidating a witness, whatever. What is the reckless disregarding? If I pull up a public document of a witness list and I go through it and I name the people, am I now recklessly disregarding my effect of intimidating those witnesses?
Could it be argued that the intimidation is the actual charges?
Intimidation, witness intimidation is the actual charges.
No. I'm saying, couldn't it be argued that charging him is a way to try to intimidate a member of the press to not investigate further?
Yes. Yeah. So he's got bond requirements that he can't contact these people anymore. He wasn't restricted from,
Was he even contacting them in the first place?
Well, he left messages.
Leaving voicemails. Yeah, he was contacting them.
He left voicemails, and he apparently did go to like a public sporting event of some sort and confront some of them in person. He also confronted them on the courtroom steps. Well, again, but all with camera in tow, asking them questions. It's all in public.
This is still it's a little dicey though. Witness this to a case, you're following them around to certain events and confronting them. I could see how a prosecutor can go for witness intimidation. It's just a problem with this.
With the right factual posture. Like, yes. I feel like I need to know more about the specifics, because you can imagine doing something with the trappings of what looks like a report, but is intended to or recklessly intimidates, right? Just because the mafia is carrying around a camera when they go into the business trying to extort the business, be ashamed of something the business happens here. Like, do you have any thoughts about things that might happen to your business and how that'd be bad for you? Right. I'm not sure it doesn't change it into not being extortion. So.
Well, and that's why I wanted
in the right factual posture, maybe.
Yeah. Well, and that's why I wanted to watch his actual streams, because they were specifically mentioned. And we only watched, I think it was 598. And we just skipped through and we watched when he was making the phone calls and the documents he was pulling up. We skipped around a bit, but I want to watch more of them, because I do have serious questions. Is this really just investigative reporting that they don't like, or did this rise to the level of actual intimidation? So I'm going to dig into it a little more. This is
some real legal analysis we're doing here. This is impressive. Wait for that. Can't we just shoot off
look at that. Look at that. I didn't come to an immediate snap judgment. And I'm like, geez, I'd like to know more information. Let's delve into it deeper.
I want to say, so one of the allegations is that he was posting pictures of the witnesses' homes, and presumably giving away their addresses and things like that. So that was one of the allegations. I said, that sounds bad, right?
That does sound bad.
Going through this, it's a photograph, at least the one that I saw was a photograph of the crime scene contained in the indictment. That's not necessarily posting a picture of the police officer's home. So like I said, I want to go through the rest of these, and I want to see what's out there. Is he really just posting photographs of the crime scene, which happens to be one of the officer's home, or is there more to it? And again, just to try to be fair, he allegedly was also using somebody at the dispatch center to do reverse lookups on license plates and get that sort of information too. So he might have gone a little too far with that, trying to identify names and addresses from license plates.
But it's tough. Here's the issue on these kind of statutes. And that is there's something called overbreadth. And overbreadth is a constitutional question. And that is, if you have a statute that can cover legal conduct that is constitutionally protected conduct and also illegal conduct, then that statute is considered overbroad. So clearly there's a very heightened First Amendment interest, especially in the political arena, when you talk about people looking into corruption, investigative journalism, freedom to speak, freedom to investigate, those sort of things. Those are all covered, freedom of the press and freedom of speech. And if this statute is somehow providing a chilling effect on the exercise of people's First Amendment constitutional rights, it could be overbroad. Now, the problem is that the prosecutors will say, well, the intent is the element that brings it out of that, because a true journalist will not. And then the follow-up to that is intent is an issue for the jury. So now we're going to take journalists all the way to the jury because we can't determine somebody's subjective intent, that only the jury can do that. And so the effect of such a statute, even with such a mens rea element, can be to provide a chilling effect on lawful press. So I have a problem with such statutes in that regard. However, I think both you guys have made good points that we do need to kind of know the facts of it. And it does need to be that, but this type of statute is dangerous to our freedom.
Yeah, I think the statute, I think you're right. I think the statute could be. It all depends on, because again, if you're talking about interpreting statutes, there's also judicial rules about, interpreting it to avoid some of these issues. But I also think, though, just based on what we've been told, phone calls, right? Following them to certain places, looking up their license plates. I'm not saying again, but it gets real close to it, though. You know what I mean?
Okay, stop it. I got to ask one question. If this was Channel 9 News or whatever the local news affiliate was, and they're doing the exact same thing, which we've seen 1,000 times every day on the news, this wouldn't even be a question. But what we have here, and this is
I'm not sure Channel 9 is necessarily doing all those things. This might be part of the problem.
What I want to bring up.
My thought, guys.
Yeah. And I disagree. It could be a problem. I disagree.
It could be, but I don't see it very frequently. And then number two, I'm especially concerned in this case because the person involved who died was a police officer. The location that he reported in front of, the supposed house, is a police officer. There are actual questions, it appears, coming up on what really happened in this incident, and could it have involved the police officer or police officers or somebody? We don't know. And so when you have the police officers who are part of the prosecutorial team and then the prosecutors, there's a chilling effect here, which I think Steve was saying. And those are my questions as a conspiracy-minded, fine, red-blooded American.
No, and what I was going to say is, we have, and I'm sure every city has them. We have the the Hall of Shame guys, a local news reporter that tracks down the contractor in his home or in a parking lot, and then the contractor, the business is owned by the wife, so then he tracks down the wife, and they get the camera in his face, and they're like, "Tell me why you stole this little old lady's money." It's the same thing, but it's sanctioned because it's Fox News or it's NBC or whatever, and maybe it does. Maybe it is the same thing without a distinction. They just decide not to prosecute. But I mean, the
thing that you just said,
I'm pressed.
Is this case in the? Because I'm assuming maybe I'm wrong here because my opinion can change dramatically right now. I'm assuming this case was in front of a this was in court. Right, that this where you get witness tampering, right? This was not because like the example you just gave of the those generally aren't in court yet. They're just hey give this person back their money. But if they were in court, then maybe you may have a different story with the witness tampering. So in this case, that I think is a distinction here. If you have if it's actually being litigated in a criminal court and these are actual witnesses, now you have a little different posture.
Okay. How many times do we see such and such and such? No comment. Such and such and such. No comment. Sam Bankman-Fried. Do you think the reporters are saying, "Oh, we won't ask any questions. We won't follow him around"? I'm just saying. I do think that this is the quote credentialed or attempted credential differentiation. This guy is a blogger. He's a YouTuber, and my personal opinion is that he is probably not afforded the same rights that you would see for a local affiliate or Fox News.
Well, Sam Bankman-Fried is the defendant, so it is a little different than a witness to the case. Well, maybe if one of the witnesses, if people are going to his house, making the call, that type of thing, we're talking about a different story because we're talking about witness tampering. So
see, I have a problem.
I don't know.
I got a problem with that.
Again, I'm not saying it is, but I'm just saying it's not that far away from it.
I think you people. Where is it defined? The press, the freedom of the press. Our rights are individual rights. They are not corporate rights.
This is why I think this is the totally wrong way to think about what freedom of press is. I think freedom of press refers to the literal physical device, the printing press, the technology. I think talking about a journalist as being part of the press is a complete mistake. Yeah. I don't think freedom of the press applies to the New York Times or the Wall Street Journal or any of that, because you have freedom of press individually. It can't mean the Washington Post. It has to mean you. And the only way that makes sense is that it means the literal freedom to use the actual physical device, the literal physical printing press. Freedom of press refers to the ability to use technology to spread message. Freedom of speech is what you say. Freedom of press is the method, technology, or methodology by which you say it. And that's the only way it makes any sense.
Yeah. Right.
So that's what I think.
Exactly.
No, that's
right.
Dropping common law knowledge.
These are the Bill of Rights are individualized rights that protect the individual and the press. When we say press, that means the ability to speak to others in a group setting, to broadcast your views and associate with who you want. And free speech and free press, to say, well, press is some corporate entity. Well, where is that defined? Where does it say that? What other right in our Constitution protects some kind of corporate conglomeration that some elite gets to do? No, this guy is press just like I am, right? MLS law?
Yes. Yep. There's no distinction for journalism. I agree. I agree 1,000%. But then I would also say, I think what we're really talking about is selective enforcement or selective prosecution, because like most of us have been saying, if one of these people under that, the media, if the media or somebody with those credentials were doing something similar, we are saying that they maybe have been treated differently, which again could be the case, and I would say probably is the case.
Partly because Fox has how many lawyers on staff versus Turtleboy, how many lawyers do you have on staff? And you know that these calculations are considered, that if it were Fox News or a network, or the prosecutor might just have a little bit more pause before going after it, especially because of the reach, because Turtleboy's he's an award-winning journalist according to his blog. I hadn't heard of it. I think he's very regional. I don't know what his reach is, but that's a factor too. Like they can push him down a lot easier than they can the local affiliates, or even worse, the national news. And that's part of why I would like as much exposure on this case as possible. I guess he went on with DUI guy yesterday, and I'd love to interview him myself. I'd like to hear about the case, because the case actually sounds interesting, because of the whole, you think it's one thing, but maybe it's another thing. And it sounds like even they are confused. Like Reed herself is confused. She apparently maybe thought that she did hit him and didn't know it or something. And then evidence is just coming in that's very odd. Jeff, I know that you're well up on this, so.
I haven't looked at this for a couple of months, actually. So I haven't had time to read anything about Turtleboy. I saw people's headlines and hadn't had time to read it. And Lauren De Laguna, she's going to be on with me tomorrow, and I know she's close with Turtleboy in the case, so I was going to ask her for an update on it tomorrow. I was going to be lazy and have someone else tell me about it.
There you go. No, you tell me about it.
Okay, Nicholas Starro has a question here. What's the difference between Turtleboy and the Marion Count Records raid?
Yeah, that was Nick's been covering that. That was a small little like mom and pop newspaper that got raided by the police and all kinds of stuff.
That one, yeah.
And the woman died the next day?
Yes. Yes. But I think I think the difference in that one was that that was clearly corruption. Now that police chief has been suspended, like it was clear they were trying to stop that story from coming out. And then
On top
and
of
it came out
everything
the
else, it was
judge,
First
right?
Amendment retaliation.
Yeah, and the judge, like they found out the judge had even had to do it was like that case is insane. That case is insane.
Well, anyway,
But to me, there's no difference. Just because the difference between the New York Times, this mom and pop newspaper company, or Turtleboy, there is no distinction at all
Legally,
between
yeah.
these. Yeah, legally.
There can't be. There can't be any
There's no
distinction.
legally between them.
Or
Do you think we're ever to the point where press, reporter, et cetera, is defined somewhere? Are we
But
going
it
to get
can't
to
be
that
because
point?
I hope not.
because
No,
but,
it can't
but, it,
be.
but it can't be because the we were
Well,
saying
Nate,
before.
it shouldn't be. It can be, but it shouldn't be.
It's like defining it's like defining freedom of speech only for a particular group of people who the government says can have that right.
Yeah.
Freedom of the press is for everybody. It's not just for the newspapers. It's for me and you. It's the way we communicate. It's not about the communication itself. Freedom of speech.
It would be.
About what's said.
Sure.
Yeah. It's comparable at least also to freedom of religion, because freedom of religion is individual.
Not only for the
Like
church.
the religion of one is no less important than the religion of a billion, in sort of its fundamental religious aspect. It's like what the First Amendment is designed to be.
Ooh, this is
Because we have the de facto press, the mainstream media trying to say we're not press, we're not media, our views aren't valid.
They're not press. That's my point. No one's press. That's the whole point.
Yeah. Now, let's go into this chat comment right here. This is significant too. Now, again, we have the police. They're on one end of it. Now they seized his devices, his computer, everything else.
Of course they did.
Come on now. You have to. Where's the firewall in this? Where's the firewall? Because that's a very legitimate question. If somebody's investigating the actual entity who's there, and that entity can just seize their stuff, that's chilling. I don't care how you put it. It's chilling.
Well, the firewall, of course, is always with the judge. I mean, but you got bad judges. That's the problem.
Well, who's opening it? Who's investigating it? When they seize it, who actually pries it out? Is it gone to the FBI? Because then that could be maybe a neutral arbitrator. Could it go to the state? I don't know. But if the local police and the prosecutor get to just pull everything out, that seems very weird.
It was interesting because the prosecutor also mentioned an unnamed co-conspirator, but no one else that I know of was charged.
But that's well, if you have like an unnamed or even unindicted co-conspirator, that's the snitch or somebody who is working with you, and you can say this person is doing bad things too, but they're working with us, so they're unindicted co-conspirator.
Maybe the conspiracy is with his own chat. That'll be good. His entire chat was egging him on. They're part of the conspiracy.
Yeah, that would be
the unindicted
chat.
I got a couple little bit of research. I'm sitting there researching as we're going. Supporting the free speech clause was seen as covering the press as technology. All those who use printing presses to try to communicate to the public at large, and not the press in a specific sense of industry or occupation. And further,
that's what I said.
Right, exactly. This is from the Heritage Foundation for the Constitution, Guide to the Constitution, and then also free speech and free press clauses have been read to providing essentially equal protection to speakers and writers, whether or not they are members of the institutional press, and regardless of medium. And that's from Reno versus ACLU, 1997.
I think people are mixing up like press credentials and credentialing press.
Yeah.
That's usually at a state level. So like in New York City, if you want to have access to certain things, you would get credentialed at the local level. But that has nothing to do with your right as a member, as a member of the press.
Even MLS got press credentials in the Orlando courts, and Steve is my field correspondent. He's got his little press pass and everything.
I tell you right now, one civil law is getting press credentials for Fulton County, Georgia courts because I'm camping out right on their lawn during the Trump trial, broadcasting right from the sidewalk.
It's going to be great.
Do it, definitely. And I think that, okay, so I want to make sure as a civilian, I'm interpreting it correctly. Essentially, then the amendment is the speech is protected as well as any tool used to amplify the speech. At the time, it was only press, but now that could include television, internet, books, etc. Would that be a fair interpretation?
Yeah,
Well,
books, of
scroll
course,
down to scroll down a ways, and
it's all the printing press. It's just a little bit more modernized. You know, I like, if you think something like a text message or Facebook or Twitter, it's just the printing press. It's just the same old printing press it ever was. You have a slightly different keyboard, and you know, you send a message over a wire instead of inking up the thing, and it displays on a screen instead of on a piece of paper. It's just the printing press. It's the same thing it ever was.
One includes radio, and
one is,
go down to about
right?
0.3 there. You're going to see there's a couple numbers there. You're going to see a 0.3. We'll scroll it down.
One is the speech. One is how the speech is conveyed.
There it is. Look at 3.
To speakers and writers, whether or not they, yep. Okay, here we go. Books, newspapers, movies, the internet, which they commute. So,
oh, that's Reno versus the ACLU in 1997. Okay,
yeah.
So that's a case.
Great case.
Yeah, it's a great case.
Okay,
I've never read it.
Well, you can cover those cases and more on Uncivil Law.
But I will say Turtleboy is a member of the press in terms of any constitutional analysis. He would be considered a member of the press.
So we have to start with that presumption.
Yes.
Because he's a citizen.
Frame this.
All citizens are members of the press.
Yes, exactly.
All permanent residents, at least, and beyond that, we'll look a little bit more.
It helps to I think get people past that notion that it's only the New York Times, right? He is a member of the press.
It's like the free speech zone. See, this is the free speech zone.
Yeah.
You know, I thought America was a free speech zone.
okay.
That was your man on the
sent this
street
in.
interview, Steve, right? He was quarantined to the free speech zone.
Yeah.
Do you guys know this case? David Daleiden is being persecuted in California because he is not considered part of the quote press, so he's not afforded the same considerations.
See, when you say that, I need to know a lot more about what exactly is the nature of the prosecution. What exactly is what's going on?
Who he
There's
is,
state law issue, so certain things like that.
Well, okay, hold on. That's a good question. Let's say there is a state law. Let's say there's state law saying that you can only be press if you're credentialed by a license from the state. Would that not go ahead against the Constitution?
It depends.
Yeah, but I don't know.
It might be. It depends on the context. Like if you're talking about a specific location, like for example, like the U.S. Senate, for example, hands out press credentials. Also, incidentally, that's how you become a White House press reporter. They're the same credential.
Yeah.
But yeah, you could do it as a time, place, manner restriction because basically it can only hold so many people. There's only so many people can physically be there. So we need to have some sort of method to choose who's going to be there on some day in a way that's some sort of neutral. And if we do it based on reach, for example, because we want to reach the most people, that would be a neutral consideration. So it might be legal. What is the press pass?
So
under what circumstances?
I don't know this whole case entirely. I just pulled it up, and it looks like in 2015 he did some surveillance video, and it sounds like California's probably a two-party consent state. And then he published it of an organization, Planned Parenthood, and they were talking about how much fees to pay for certain fetal tissue and things like that.
Yeah.
And so he published that, and they said, well, it sounds like California would have been a two-party consent state, and so that was the illegality. That was in 2015.
Well, and
he was ordered not to publish that.
Actually, I've challenged that. We have a two-party consent state in Florida, and I've actually challenged that constitutionally under overbreadth in a particular criminal prosecution that I did. I actually tried this. I asserted the U.S. Supreme Court on that. Of course, got denied. I'm still working on it. I'll get my certificate. But and on that two-party consent, in the case that I had, the targets of the two-party consent were police officers on their cell phones in the performance of their duties, which at a cop office, cop uniform, cop cell phone during the performance at work, and the guy recorded him without his consent. And my argument was that the Constitution absolutely protects that type of recording, and that barring that, it was overbroad, like we talked about overbreadth. Now, there's a different question when you have citizens involved who in a two-party consent, and I haven't looked at that particularly, but that's a different question because the First Amendment, remember, the constitutional guarantees go to government action. They constrain government action, not individual action between others. Like I can discriminate against MLS law because I don't like bearded people, right?
Hey,
as you should.
Hey, wait a second. And but you know, and it may be the government to do that would be unconstitutional, but for me to do that as an individual is completely fine.
Shouldn't that be going up to the Supreme Court? Because if I recall, if I call somebody in California, which is two-party consent, from here, I'm in Virginia, which is one-party consent, they can shove it. And I can.
That's not what California says. California Supreme Court actually said the reverse of that.
But that doesn't make sense because now we've got a constitutional states versus federal problem, don't we?
I agree.
I think it depends on it's if I'm intruding into your state that versus where the call is coming from.
Can it really depend on who called who? Can it really be that?
I think it's.
I have a question for uncivil on that because
ridiculous.
I actually have a case on this, and you have a little breadth of knowledge on some of these things involving state long-arm jurisdictions. To drag somebody into the court across the country when they're just speaking, say, anonymously on some chat board, and it affects a citizen, say, of Florida, can Florida grab them from long-arm jurisdiction and pull them into court?
As what? Just like as a witness or as someone to charge?
Your speech is criminalized because maybe it's a threat.
Oh no, I don't think so.
Yeah, that's
you need to. I think I'm going to go try to do some call dare international shoe kind of thing and talk about minimum contacts.
Wasn't there a case just recently where it was like a car repair shop in California sent troopers to go arrest some guy in like Pennsylvania and bring him back? I can't.
And got his car. They seized the guy's car and everything and returned it. I vaguely
Dog the bounty hunter went all the way to Mexico to get somebody.
Yeah,
I mean, these are state actors, California
state
actors that went to like Pennsylvania to pick up a guy and arrest him and charge him and seize
I
his property.
don't think that California can actually conduct the arrest in Pennsylvania. No. I'm pretty sure they'd have to get Pennsylvania to conduct the arrest and then do an extradition unless he's already. Yeah, it's like you can't just arrest him there.
Under the Interstate Extradition Compact, you can't challenge the underlying substance of the charge. It just has to be legally sufficient. And so you can't, the extradition, they could get a warrant, get the extradition papers, and the charge can be completely bogus. Actually, I'm in charge of extraditions in our office and have fought multiple extradition people. And it's really very weak. The Interstate Compact on extradition, I mean, we had a case where the court itself was without jurisdiction that was granting the warrant, that was asking for the warrant. It was a juvenile court in another state, and my client was like 24 years old. But they honored, and I tried to challenge the jurisdiction of the court, and it wasn't even signed. It's very complex, complicated issue, but it wasn't signed by the executive branch in that state, the warrant, extradition warrant, because of crazy rules in this jurisdiction. And it's like, that's okay. It's the governor's warrant signed, extradite him. So it's like
you just said it wasn't signed by the executive, so I'm confused.
Well, because in certain areas of Mississippi, 4 counties of Mississippi, you can actually have citizen felony complaints. So citizens can actually charge people criminally by filling out affidavits. So the warrant was based on a citizen affidavit complaint charging a criminal charge, and they sought extradition based on the citizen complaint.
And you couldn't get it bounced because
they extradited.
I still think you need the extradition warrant signed by the governor, but that's another issue for another time.
Yeah, that's the statute explicitly calls for that. But then what happened was the governor's office just signed it.
Okay, well then that's a problem.
Yeah. I just thought of something. Have you guys?
I want the nice fancy extradition paper with the fancy seals and the calligraphy and this, the metal seal and all of it, man.
But the court, to me, the court there does not have the basis for the underlying basis for the extradition was invalid.
No jurisdiction.
But it's like, I'm without ability. It's like, well, challenge that in Mississippi.
Hey, back one a little bit. Have you guys heard of the show Crank Yankers?
Oh yeah.
Yes.
Yeah.
Which tube is that on?
Well, that brings in the two-party consent state. They recorded it in Nevada, which is a one-party consent state, and they were calling into California.
Oh,
California have an issue with that, man.
Well, apparently they managed to do the show for all this time, so for a while, and that's why they did it. And I think that was actual a network show and everything else. So there had to be lawyers involved who said,
"I'm sure."
Anyway,
Well, it's
I
all
just think-
fine until California says it's not.
But you know, while we are on California, I know Nate wants to tell us about one of his YouTube heroes who is in California and is running for president. Cenk Uygur of the Young Turks.
Yeah,
who was not born in the United States.
Well, hold on. Let me let him explain to
Neither
you
was Obama.
why he believes he can run for president, even though because it's not really about being born in the United States. You could be born, let's say, if both your parents
Natural
are
born
American
citizen.
citizens,
Yeah.
and you're
Like,
Actually, it only needs to be one parent.
yeah, look, it's true.
My son, who was born to an American, me, and a Korean mother, born in Korea, he can run for president.
Yes, he's a natural born citizen. So it's
Yes.
really the generally
They're talking about paying taxes, boy.
they used to have the what's it called, the one breath. If you take one breath,
Yeah.
and you're not a citizen, and then then you're naturalized. But anyway, here is his argument. Let me display his argument.
All right, this
Why
should be
he
good.
believes
I'm here for it.
I'm amused.
And now remember, I
Is he
want to be
Is
very
he going to
clear.
go with it's unconstitutional?
Well,
That'd be good.
Hold on.
I was on Twitter recently.
I do want to make it very clear that he is this guy has a Juris Doctor from Columbia, so he is a lawyer. So just to let you guys know. Now,
I need
Okay,
to get
never
one from
knew that.
America.
here we go.
The case law. And the Supreme Court has already ruled in Schneider v. Rusk. I asked you guys if you would do graphics. Do you have those graphics or no?
We do. Yeah, let's put up.
So and I wanted to show you guys this so you can see it with your own eyes.
If you have
Thank
to use
for,
graphics, it's
humoring me on
probably a
that.
weak argument.
And so this is from a law review article in University of Illinois, and it shows you definitively that Schneider v. Rusk has already decided this issue. So they had an issue that came up where naturalized citizens were being treated different than natural born citizens. So here's what the court wrote. This is the Supreme Court in that case. The statute proceeds
I already know
on
where
the
this is going.
impermissible assumption that naturalized citizens as a class are less reliable and bear less allegiance to this
Oh
country
my God.
than do the native born. This is an assumption that is impossible for us to make. Moreover, while the Fifth Amendment contains no equal protection clause, it does forbid discrimination that is so unjustifiable as to be violative of due process. A native born citizen is free to reside abroad indefinitely without suffering loss of citizenship. The discrimination aimed at naturalized citizens drastically limits their right
What did he read the whole case?
to live and work abroad in a way that other citizens may. It creates indeed a second class citizenship. So the Supreme Court ruled it is unconstitutional to discriminate against naturalized citizens.
Let him finish.
This issue is actually already
Do
settled.
I have to?
Yeah,
Just no one knows it. So I'm going to try to get this albatross off of all of our necks. If you're one of those 25 million Americans, that alone is a reason to go to jankforamerica.com.
Go ahead, Kurt. Let him know.
Okay. The second word in the court's decision, what is the thing that is preventing this analysis from working? The second word in the court's analysis was statute. This statute, ... If you go back to the previous page, this statute proceeds on the impermissible assumption. The problem is that the thing that's preventing the disqualification is not a statute. It's part of the Constitution.
Well, hold on.
It goes further. Nate's got more.
Yeah, you have to. Well, you have to. I think you have to go through the whole. Well, let me play the rest of his argument because he does kind of address.
No, I really don't, because he's talking. He's talking about the fifth. He's talking about the Fifth Amendment.
Hold on, Kurt,
which is
at least listen to the rest of what he's saying, and then you can tear it out.
But I already know the answer.
All right, so listen.
This issue is actually already settled. Just no one knows it. So I'm going to try to get this albatross off.
If a tree falls from the forest,
if you're one of those, I'm doing, because I'm going to our side. I'll read one last thing. Thank you.
Fred Flintstone, you're wrong.
The law review article of University of Illinois concluded this should be the end of the story. Schneider is clear that treating natural born citizens and naturalized citizens differently is contrary to the Fifth Amendment. Forbidding naturalized citizens from being president or vice president is a form of discrimination that limits their options and treats them as second-class citizens. It is not permissible. It is unconstitutional.
So
now he also makes the argument a little later that
Kill me.
because this is an amendment to the Constitution, The parts that we're talking about being natural born are in the first part of the Constitution.
Uh-huh.
Marbury v. Madison, for instance, right after the Constitution. So right after the Marbury v. Madison was like, well, this amendment changed the Constitution. And people were like, that's insane. It was done. But anyway, so he's saying that since this is an amendment, it overrides that part of the Constitution that requires natural born citizens. And that's why it's an amendment. So that's essentially his
Didn't
argument.
we have an amendment that specifically addressed the presidency already by limiting them to 2 terms?
The 12th,
if they,
12th
if,
is
I
on
feel like
point.
if they
The 25th is on point.
pass,
I think the
an amendment
20th
that specifically addressed that, they knew how.
Yeah. He's basically trying to argue for repeal by implication. And
Well,
no.
He's saying
Mr. Younger, I want you guys are all stuck in your law and your legal brains. I think that every good-minded progressive needs to cast their vote for Cenk Younger. I think he needs to run for president, and all you progressives need to fully support, and you need to make a point by casting your vote for him for president. Absolutely, this upcoming election.
I like the way you think.
Well, but Kurt, I was saying, Kurt, let us be Kurt. Kurt, explain it. Tell them why they're wrong. Go ahead, Kurt, because you try to get in there, and I kept cutting you off.
Well, first of all, I want to challenge Kurt and say he's right. That statute is unconstitutional.
Go ahead, Kurt.
It very well may be. It very well may be that the statute's unconstitutional. I am not disagreeing with the court in Schneider. That statute may well be unconstitutional. The problem is that this is not a statute. It's in the Constitution itself, on par, on even sitting with the Fifth Amendment itself. So it's like the Fifth Amendment says this. I'm like, yes, but this provision of the Constitution says this. And so you're basically, and then he's trying to overcome that by repeal by implication. He's like, okay, when they passed the Fifth Amendment, one of the things they were trying to do, incidentally, by the way, the Fifth Amendment, of course, in timing, is passed, what is this, 1791?
Yeah,
right? When it's ratified. So apparently one of the things they were trying to do within 20 years is be like, no, we really want to change our mind, but we're not going to mention it explicitly. We really want to repeal that provision about not natural born citizens without mentioning it by name. Of course, we're not going to, actually say that part or change it explicitly. We're just going to repeal by implication.
Yeah, it's
sure you are.
2, Section 1, Clause 5.
Yeah.
Well, listen, I'm going to make it even easier. I actually, he's quoting a law review article. I'm just going to go and look when you look at the actual case. So let's look at the actual case. And in the actual case, so because I'm an idiot like that because I actually look up the cases. I was like, oh, this is interesting. I didn't know this was already settled. So here's the case: Snyder v. Rusk, Secretary.
That's right at the bottom of the case.
Yeah.
So he says it directly.
So I looked at the case, and this is what it says. Right. We start from the premise that the rights of citizenship of native born and of the naturalized person are the same in dignity and are coexistent. Coextensive. The only difference drawn between the Constitution is that only a natural born citizen is eligible for president. I don't know how he missed this part.
But he missed the very next
law
sentence.
Review article. He failed by referring to a law review article first in his support.
No, but in the actual case, they say, yeah, everything else has to be equal except for this one thing.
Well, I just fully support Mr. Younger's quest, and all good-hearted progressives must see that this is absolutely discriminatory, and this needs to be changed. And what better way than casting your vote for Cenk Younger for president?
But much of what Cenk Younger says, it's out of context, dishonest, broken, unintellectual, stupid, and a waste of everyone's time.
But how much of a self-own could you get? Because this is no argument. He's on TYT. This is what it is. It's he says it's a knockdown. But in the case he cites, and not only that, they bring up this court, right? Brings up 2 other instances in the Constitution where they treat natural-born citizens different than regular citizens. For instance, if you want to become a senator, you have to be a citizen for 9 years. They say, well, that doesn't make them a second-class citizen because if you're naturalized, you have to wait 9 years before you become a citizen. If you want to run for the House, you have to wait 7 years. Article 1, Section 2. So they said none of that has changed. What he's doing is he's read a law review article, and that law review article came to this conclusion, but he never read the actual actual case.
You're
Or
assuming
thought about
good
it.
faith and
Or
This
honesty.
thought
guy
about
has
it
a
for a second.
JD.
The actual case says, yes, he's right in all these other instances, except in these 3 instances, it's obvious you're wrong.
This guy has a JD. I remember, Kurt, a while ago, maybe a year ago or so, you had a bunch of people throwing in chat like, oh, look at this definition of this or that. And you pointed out rightly and very sternly that just because a word or something is defined in one statute doesn't mean it applies to this other statute. This guy has a JD and he's making these arguments. It's I don't know.
Hey,
It makes my brain parts hurt.
Okay, hold on. What do you call the guy who graduated last from medical school?
A doctor.
Doctor?
What do you call the guy who graduated last in law school?
Politician.
Yeah, no, did he pass the bar?
Well, it depends because a lawyer.
Not even graduated
He'd
last.
still be a lawyer. He'd still be a lawyer. He wouldn't be an Esquire though, but he'd be a lawyer.
Right. So anyway,
I say a politician.
I like it.
Jake Huger, right?
Well, there's a variant too. A lot of times people would say military doctor for my first example, but anyway, I won't go there.
But the interesting thing, because Twitter's now put like this, because that's the big issue now, is that Twitter has put this thing on his announcement that he can't run because he's not a natural born citizen, and he's saying that that's wrong because he's going to fight it, and but it's clear that even the case that he says this case is he's automatically right. He knows he's right. This law review article proves it, but he never read the actual case.
Because I don't think so, Nate. I think you're wrong on that. He knows damn well what he's doing. He's going to raise money on behalf of his presidential campaign, and now he's got a good faith belief that he can do it. Otherwise, it would be called fraud. So in order for him to get out of that, he's got to put forward this good faith argument that he really believes he's saying. But I don't think he believes. I think he knows damn well that he's not qualified to run for president because he knows Article 2, Section 1, Clause 5. It's in the U.S. Constitution. He's a lawyer, but in order to avoid any kind, if somebody donates money to them and that he's disqualified, he can say, "Well, I thought I had a good faith belief, intent."
Well, none of he's citing a case where they said, "Well, yeah, but those are you can't run for president, right?" The case that he's citing, you can't run for president.
Arguments. I don't think he's being honest. I think he's a dishonest.
I like insignificant in the chat.
He
He's
has
like,
a book out, folks.
okay. He can run. He just can't be president.
That's true. He can run, but you can't even get in the
ran for
right?
president and took money to support my presidential campaign, and you are not eligible to do so. To me, that would be a fraud.
I think you have to have the petition.
I don't even know that he's going to be able to get that because he's not going to get the registration with the Federal Election Commission.
How can you
going to bounce him?
But how can you get in a ballot if you literally, it's like being 25.
He's not going to be able to raise money with the cover of an election because he's not going to get registered by the
But
FCC.
you can buy his book on his presidential campaign tour.
That's very exciting.
Yeah.
You don't want his book?
What would be the point of running if there's no chance of him winning? Well, there's a lot of cannon fodder politicians out there. In my district and stuff, we would run certain people just because we knew the Republicans weren't going to win, but we put a candidate out there.
But everybody should vote. All you people that support the progressive cause. I'm telling you.
Definitely. I mean, he's
write his name in. He's a write-in candidate. He should write his name in just to send a message to the man.
Good point. I want to go to Jeff. YNW Melly.
Yes.
What's going on, man?
Case is fucked up.
It's a very lengthy question.
That's why we're doing it here. It's a segment.
Yeah.
Bye, Nate.
Wow. Nate's out. Kind of goes to what we were talking about with the interstate jurisdictional issues, or inside the state, but it all kind of went to hell after the lead investigator was essentially caught enforcing a search warrant outside of his jurisdiction, and to try to cover up for it, he allegedly instructed or asked one of the local deputies to say he was in the room when the search warrant was served, and the ensuing tussle that resulted in the cell phone of the defendant's mother being seized forcibly from her. And allegedly the other officer's reply was, "Well, I was in the room if you needed me to be." The problem was they made that statement in the presence of someone from the prosecutor's office, the prosecutor who Her job for the last 20 years has been prosecuting prosecutorial and governmental misconduct.
Nice. I was gonna say a
So she
prosecutor
reported
with
him.
a soul. Nice.
Yeah,
Good
so
for
she
her.
reported him.
That,
now there's
Prosecutor
motions
actually
to
holding the accountable. Nice.
it gives me
There's motions to
hope for the
recuse
system.
the entire prosecutor's office. The judge is in the middle of considering a motion to dismiss the double murder charges. They're up against the 3-month speedy trial time limit. They have to swear in a potential jury by a week from Monday.
Wow.
And
I
the prosecutor got thrown off the case today.
And I've volunteered to prosecute this case for that office. Given the right remuneration, I will quit my job, drive down to South Florida, take on this case, learn it front to back, handle every motion, pick a jury, and try this case for them. I am board certified criminal trial law in Florida. I'm your man. Of course, you have to compensate me for all this.
I want to
effort.
see that. Oh
But
god,
wouldn't
I
that
hope
be cool?
happens. That would be amazing.
Yeah.
I just want to
I'd
say,
be- I'd be in
prosecute
they
Melly.
provide themselves out of this problem. I won't. First thing I would do is
Or you can get me. Steve here will vouch for me for Pro Hoc Vice, and I'll prosecute it. It'll be fun.
You'll fly in to do press coverage. I can see it now.
Yeah.
Wouldn't that be cool?
But the interesting thing part was, like I was saying, the lead prosecutor who prosecuted the entire first trial. This is a retrial. She was thrown off the trial. She was thrown off the case today. Her and some other people, because the decent, doing her job prosecutor reported what she overheard these guys say to the lead attorney. She sat on it. And it turns out also the guy was the subject of an internal affairs investigation.
Sure.
But the internal affairs people, they shelved it allegedly so that it couldn't be used to impeach him when he was on the stand. So they sort of shelved that. But she told her superiors, the lead prosecutor told her superiors, and the judge yesterday said, well, they had a big hearing last Friday, which is why I was late too. The defense said, well, she's now made herself a material witness in this case. So she has to be recused from the case along with everyone else she told. And that's what the judge booted her off the case today. And now
I
they've
don't know
got
if
3
everyone
days
she
basically.
told would have to be recused because she's
Well,
a
that's what they
necessary
wanted.
witness, but I'm not sure about that.
Because they want to call everyone else to say it was an institutional, basically a conspiracy to suppress this evidence and hide it.
My point is, I think that the office, in order to get rid of the cloud of impropriety that is hovering over the state attorney's office, that they need to bring in an outside guy who has prosecutorial experience, who has the ability to
how many books?
Prosecutorial experience from 40 years ago, but
no.
Listen to this. Steve proved earlier on in my stream how he is literally the only person in Florida qualified to do this.
I am. There's I am an expert on speedy trial. I am an expert on criminal trial law.
I
My
think an
board
email
certification
needs to
is
go
criminal
out.
trial law. It's not appeals. I did prosecutor for 6 years. I'm death penalty qualified in the appellate world. But the first thing I would do in response to the question in the chat is I would take the death penalty off the table because I don't think this is a death penalty case. But with that restriction, I would definitely take this to jury. I could pick a jury next Monday, no problem.
Can the Attorney General, I mean, assuming you guys still have one in Florida, can't the Attorney General take over the case as
Yes.
Okay. And so
they
with
could.
the
They could
State
hire,
Attorney
like I
General,
said, we had a local prosecutor here on a first-degree death penalty case that paid an expert witness, not the lead attorney on a major homicide, who would have to drop everything and quit their job in order to take this case, but just an expert witness. They paid $270,000 to that witness, and they came back with a manslaughter lesser. So I'm just saying, the state's got deep pockets, and I've been a good, loyal, tax-paying citizen for many times, and I don't have any interest in any party. So I will run this trial fairly and honestly and down the middle, and that's what I'm ready to be hired. And so they can't go there and tell that judge that this sanction against the prosecutor for disqualifying them is too great a burden, because they could do it if they wanted to. There are options for the state if all they have to do is pick it up. So I'm just telling Mr. Melly that there are options for the state and they don't have an out.
this needs to get out there. This needs to happen.
Clip that and broadcast it everywhere.
You'd really switch teams?
For the right, I would quit my job today for the right amount of money for a month. And I guarantee you my boss would hire me back after I was done with this little prosecutorial endeavor.
And then you handle your own appeal. That'd be fun.
No, this is in South Florida. I'm just talking about the guilt phase of a death penalty, of a capital murder trial, of which I would take the death penalty off. It would be a life in prison case. Absolutely could do that tomorrow. I'll just get that box. I'll go through it. I'll handle all the motions. I'll do it all for him, man. I could do it. Give me that challenge. It would be fun.
So is this trial going to go forward on the date originally scheduled?
Yes, it must. If it does not, it's dismissed with prejudice.
With prejudice. All right. It's going to happen. Wow. Man, that's a lot of stress for the new.
You're actually going to get a case dismissed with prejudice on a speedy trial motion?
I know.
It's very possible.
It's amazing for a prosecutor. If you've ever read the Florida statute on speedy trial, because there's constitutional speedy trial and there's statutory speedy trial. We're talking about Florida statutory speedy trial. For a prosecutor to lose a case on speedy trial grounds is practically impossible. I mean, it is so ridiculous the amount of steps that have to go through. A prosecutor really has to screw up bad in order to lose.
And they have
speedy trial grounds, and they're doing it. It's amazing to me. I mean, I'm like, how do you mess this statute up? It's so.
And that's literally what the judge says. You have until the 23rd to start swearing in jurors, and they've said they are filing the motion on the 24th. Go.
Yep. Oh, absolutely, they will. Sure, they will. They'll move. It's.
I'll file 23rd at 5 p.m., baby.
Nice. Hey, I got to jump off, Eric. Thank you very
man.
much. I got to get downtown in about an hour, but thanks for having me.
Thank you,
everyone. Jeff, Kurt, and Steve. It's good to talk to you guys, and take care.
See you later.
I'm going to jump to another topic. And I'm sure that Steve will definitely have opinions. I think everybody will, but I find it kind of interesting. And somebody wrote an article. Oh, come on, add that to the stage. Talking about Trump and his cases and the fact that he's sniping at the court, at the clerks, and other people. And I know a judge in New York literally put a gag order on him. So I figure this is a good, lively talk. At what point and what rights do people have or not have? Shouldn't Trump be able to criticize or say things against the court as he wishes as a defendant or not? Take it away. Steve, I know, has to have an opinion on this one.
Well, I do. But see, the problem is this entire charade is political persecution. So the first thing we need to get off the board is that, we're lawyers here and we have our legal perspectives and our legal experiences, but this is not a legal process. This is really a political weaponization of our institutions against one party and one opposition party. So once that falls in line, that the whole process of political weaponization, we're not in the area of law. We're in the area of something else. We're in Banana Republic world. So to argue, well, is this lawful or is this not lawful? I feel that the entire prosecution is not lawful. It's basically interference in our electoral process. It's Banana Republic stuff. So I don't really feel legal analysis is appropriate. So therefore, let's look at it as a political analysis. Then we're talking about, because in a normal case, certain restrictions on parties, may be appropriate, but this is no normal case. This is the leading candidate this is a former president, the leading candidate of the opposition party running for president, who is being tied down in every way they can in some tin pot dictator judge in some small little courtroom in New York City who thinks he's God, trying to shut him down. And I got big problems with that because that threatens the existence of our republic. So that's what I think.
What you should do is just stand up and yell, "You're out of order." Whole trial's out of order. They're out of order. Just
Chicago
go all
7?
justice. Yeah, just go all Al Pacino on them. No, the only thing I really have to say is if you put the gag order on him, you got to put it on the prosecution.
Why don't we put it on the whole world? Why don't we put a gag order on every citizen of the United States that they can't talk about Trump ever again? And then we'll all be in contempt of some little judge.
Exactly. Because I saw that yesterday. Trump's not allowed to talk, but then you had the attorneys general going, today's day 7 of this trial. We're giving him exactly what he deserves, and we're showing you what true justice is all about. But he doesn't get to say a thing to counteract that. Everybody or nobody. That's just the way it should be.
Kurt.
Preferably nobody.
I don't know what to say about any of this. I mean, for whatever part I can play, I'm going to try to continue to do a legal analysis of the whole thing, because try to understand it in its legal terms.
Are there any?
Sure. For some of the cases are better than others. Some of them are much more shaky than others. So it depends. But yeah, not for the least reason for, of course, George's RICO is written so broadly that we just RICO everything because we're bored, I guess. But yeah, it continues to baffle me. He didn't ask it to be removed to federal court. If anyone understands that, they're welcome to try to explain to me. Some people have said it's because he really wants it to be televised in some sort of 4D chess, because I guess he thinks that the political prosecution of it all will become so apparent that people will rise and it'll become ever more popular. If that's the theory, then it sounds pretty stupid, but okay. But yeah, I'll just try to understand it on its legal merits. The Cheesebro and Powell cases are heading along in Georgia. Some of the lawyers for Georgia, so trying to cover that stuff. Exciting.
Do these petty, and I appreciate it, and that can be your bag. You can follow the law, and I will continue to say that it's political persecution, and there's room for both of those commentaries within the free press, sure. Right? But the one thing is that, do these prosecutors understand that by their pursuit of these very unusual legal theories against the leading candidate, a former president, leading candidate, endangers our republic, endangers the rule of law? Do they understand that they are pressing constitutional crises into our system? That their acts of prosecutorial creativity endanger the rule of law itself and this country's continued existence? Do they understand the implications of what they're doing? I think they don't care. I think they're on the left and they want to destroy the rule of law in this country.
How many times have we heard the word novel? That's my big favorite thing. It seems like every case out there from Jack Smith on is novel.
Bragg was really novel. That was all kinds of...
But
trying to bootstrap a federal crime into a state law misdemeanor and then turn it into a state law felony. It's like, dude, what are you doing?
I heard the RICO was novel. And I'm just curious about that, because to me, novel means something really unique, something that's never been done before. And it seems odd to me that we keep hearing novel. And this is not people supporting Trump. This is like mainstream press just saying it's a novel interpretation of the law, or a novel prosecutorial concept. Now, tell me where I'm wrong. Is that not kind of odd?
Yeah, it's a little odd.
Okay.
Next case.
Yeah, next case. Okay, I'm gonna ask a hot button question. It's something I've been asking on the side, but we can't ignore what is going on in the Middle East, what did happen in Israel, and I just want to ask a separate question that a lot of people maybe didn't consider, and I think it's on point to the first day. Mm-hmm. They have very strong and strict gun control laws in Israel. How many people have come out and pointed out, in my opinion, that perhaps if you didn't have as strong of gun control laws, that there may not have been as much carnage the first day, just simply by slowing things down? And I'd love to hear
how Israel is not like Switzerland and requires every adult male to have a machine gun in their house at all times is beyond me.
Exactly.
And everyone is already, they have compulsory service. So technically you have citizens, with a few exceptions for religious or whatever, who are trained to handle weapons. So I'm very confused by this, and I'm wondering, why aren't we asking this question
Yeah, well,
more.
Andrew Branca says, and I know that he was on saying this kind of resolves the Second Amendment debate. It's the end. I mean, this is it, because you had the what is it? The schools that they had that were defended by just a couple people with arms survived mostly. The ones that were slaughtered to the last person were the ones that didn't have any firearms to defend themselves. So
I follow that account. Girls of IDF, the girls on duty, they're in bathing suits with their rifle around their back, kick ass. It's like, why aren't they at the festival with their rifles just strung around their back at all times? And I would if I lived in Israel. Damn.
Also, people say, like, well, why does somebody need a 30-round magazine?
I see a lot of targets. That's why.
That's right. I can think of about 30 reasons right there.
Well, no, that's one of the classic lines from the great movie Nobody with Bob Odenkirk. He's talking to his father, played by Christopher Lloyd, while they're being attacked by a bunch of Russians, and he said, you brought a lot of guns." He said, "Well, you brought a lot of Russians." So it's that kind of thing. You need 30 rounds because there's 31 guys outside.
I like Trish B's comment here. She says, "Local armory." Do they keep fire extinguishers at their local firehouse? Right.
The whole round question, I always think, is just stupid. It's like, okay, so what is the right number? Is 7 a good number, or is it 20? Or who cares? Why are you saying, who needs that many rounds? Well, because they don't want it reloaded a bunch of times. It's
Israel absolutely should be arming its citizens at this point, and it's too late to deal with the last problem, but it's not too late to deal with the more systematic problem. Because the problem is not going away. They absolutely should be doing everything possible to arm all of its citizens. Be like total massive reversal. Instead of gun bans, how about mandatory? How about here they are, have 2 of them?
Ukraine also had that same thing when the invasion happened. Everybody was opening up. They were storming the armories so that every citizen's got it. And there are other countries that are on the border, like Lithuania, Latvia, Estonia, and who also should be implementing Swiss type things, which, like you said, every healthy, able-bodied male should be armed to the teeth. I want to have the good folks of my country armed to the teeth, disarm the bad folks, absolutely, but the good folks, I want them to be armed. I want the bad folks to be outgunned by the good folks.
And by the way, I don't even care about parity. Just the fact that there's risk would slow it down. Because I know that some of the people say, well, there's bad guys in Israel and we don't want them to have guns. Okay, well, yes, it's true. We'll get guns too. But the truth is that if every house potentially has a gun pointed at you, when you go to invade it, you may have to think about it. You may have to pause. And I'm not saying it's going to prevent 100% of the death. I'm just saying this disaster would not, in my opinion, have been the scale of what you saw.
Hezbollah says they want to be martyrs. I just as soon help them along, is what I say.
Well, and I agree.
Steve can talk about this. I mean, one of the largest drops in violent crime in Florida history happened when they went to the concealed carry permits in Florida. The same thing happened in Utah. They went to the concealed carry. Violent crime dropped. And one of the greatest convocation lectures I heard in university was by a former head of the KGB. I think his name was Oleg Kalugin, if I remember correctly. But he said that the Soviet Union, that's how long ago I went to college. The Soviet Union has a first strike plan. The only reason they haven't implemented it is they're not afraid of the U.S. military. They're afraid of the U.S. citizens because they all have guns.
Well, there's a in Prepare, the Handbook for Individual Freedom.
It took you long enough.
Who wrote that?
2 chapters on firearms. The first is preparing for emergencies for firearms, firearm concepts both within the law and beyond the law. And there's also a justifying citizen possession of firearms, which is know why the Second Amendment exists so that we have it when it's most needed. And that goes through all the justifications for the Second Amendment. Because what Kurt had brought up about, well, why do you need to have a 30-round magazine? That's covered in some of the justification chapter there. So
you don't need 1, you need 4.
What's that?
It's like you don't need 1, you need 4.
You need 4 books? I agree. And you can only get it at
Oh, you walked right into that one. Wow.
Anything to help my friend.
Oh God, I need to like really follow, learn, take notes, and practice, because there's nobody better on the grifting here without Nick the Nose. Okay. So we're in heated agreement, I think, on this one. And let's go to another one. This one, I think, is going to be up Kurt territory. And this is the Google antitrust case.
Yeah.
Is this something you've been following?
I've been following a little bit. Google's been having a lot of trouble recently. They recently also got sued by the FTC and 23 attorneys general as well on antitrust issues. It's not surprising that it's happening. No, actually, that was Amazon that just got sued. I'm sorry, conflating cases. Yeah, it's still not surprising that's happening because Google, is just a lot of combination of resources. This is one of the things Ken Paxton was doing at the time that all that stuff was blowing up in Texas. He went away to like Iowa or something to help wrangle some attorneys general into helping. And then like his staff basically staged a coup while he was gone that led to the whole impeachment. Anyways, but yeah, it's not a surprise because Google, it's especially in data storage, data processing, it's huge. Advertising, it's in tie-in, it's big.
Well, apparently what they're arguing right now is they're saying, hey, not only is Google making money off of all the searches and advertising, they're also paying off Apple and everybody to make sure that they are the default search engine. So they're perpetuating a monopoly in that argument. Google is countering and saying, no, we're just that much better. Their number one defense is that the government was wrong to say that it broke the law to hold on to its massive market share, saying that it was wildly popular because of its quality and that dissatisfied users can easily switch. And they claimed, I guess, further that even when other companies set the default to something other than Google, like to Bing, people were switching it back on their own to Google. So it's not a monopoly. We're just that much better.
I think there's some truth to that too, to be sure. But Google ad integration, especially with relation to YouTube and how much data they get. I mean, the biggest search engine is Google, and the second biggest search engine is YouTube, which is also Google. So the amount of data that they have on their people and the way that they leverage that for their advertising is, obviously a strong commercial advantage. The tie-in doesn't particularly hurt either.
Isn't Google effectively a monopoly in the advertising realm?
Yeah. They're a monopoly in search. The question is whether it's illegal, right?
Well, that's a good question. And actually, whenever I want to agree with some of my leftist buddies, my friends who are on the other side, I start talking antitrust law because I'm a big believer in the old Teddy Roosevelt vigorous antitrust enforcement. I think a mistake. The Republicans made a mistake by backing off and adopting the Chicago School economic analysis only, and that we need to have much more vigorous antitrust enforcement. And the reason is because these big companies are as much a threat to our liberty as the centralized government. And therefore, I would much rather have my liberty than big corporations. So that's not even a contest. And so when a corporation is so large, they're too big to fail, or they're so big that they can extract free speech concessions out of their citizens by Google algorithm, then they're too big and they need to be broken up. This is a protection to individual liberty.
On that note, or not exactly there, but I think it's along that line. Satya Nadella or whatever from Microsoft, or Nadella, sorry, Satya Nadella testified in addition to this, because of Google having all the search queries they have, guess what that gives them a stranglehold in once they get their act together? AI. So that perpetuates the next thing coming down the pike, because if you really look at it, the only threat that Google has seen, in my opinion, in a long time is AI, simply because Google depends on feeding up ads next to search results. If AI is generating an answer, like let's say I just have an AI phone and I say, hey, tell me the score today, it'll just spit out the score. I'm not going to see an ad. It completely bypasses Google's market.
Well, they did have that famous red alert all hands meeting when Microsoft announced their collaboration with OpenAI ChatGPT, which is still integrated into Bing, which incidentally works pretty well, by the way. So if you ever want to use it for free, I recommend it. It's a good reason to use Bing because it's integrated. For its chat features integrated with ChatGPT. I use it sometimes to help me with headlines for titles for YouTube thumbnails. It's good for stuff like that.
Well, it's extremely useful. And by the way, that's one of those sneaky things that over the years, Bing had a bad rap and they've been struggling, but it's been getting steadily better. Another case of that I've been reading lately is Apple Maps. Do you remember how bad Apple Maps was? It got Scott Forstall fired, and everybody made a joke about it, like, oh, it's going to lead you to a lake, blah, blah, blah. Well, more and more people are actually switching to use Apple Maps because it's gotten really good. And many argue it's actually better than Google Maps anymore because Google Maps is so spammy with ads and everything else. So I don't know. That's an interesting question. And because Bing did the AI, Bing has seen a major market resurgence that they did not have before. And I think that proves the threat to Google. But then you guys on the antitrust front doesn't actually help Google in this case. You can say, hey, look, they got together with ChatGPT and now, there's serious competition and we might be in trouble.
I have a question for the civil lawyers over here, or the uncivil lawyers, and that is that we were looking to the Department of Justice's antitrust division for breakup of these companies, and I recognize that they have been completely co-opted by these big businesses, and it's all one big elite back scratching club. However, there are also very strong treble damages plus attorney's fees antitrust provisions in state and federal, and I think federal law, but state law definitely. Why don't big firms or law firms generally, why isn't there private action against these antitrust restraint of trade competitors? Because it seems to be, treble damages plus attorney's fees is pretty enticing to and especially with these big, fat, juicy, money-rich targets that are these big companies. Any insight into why that's not occurring?
I don't know enough about state-specific antitrust law to comment.
I would just look at.
You've got me on that one.
I would look at
take a look at one. Just look at I know Florida has that, but they have many of them. Take a look at a couple sample ones. The treble damages plus attorney's fees. That's the kind of thing. And there's going to be huge damages in these corporate. They've got big firms going after Boy Scouts and other big fat deep pocket organizations. Why aren't these trusts being attacked from a civil litigator saying, why aren't there big law firms who are just making this their practice to go and take down these companies who are restraining trade? It doesn't make sense to me that the private right of action is not working in our society.
Follow the money, dude.
Well, that's what I'm saying. The money should be an incentive to sue the hell out of them.
Which tells me that there's a cross incentive that you're not seeing. That there's something.
And I'm not a civil lawyer. That's why I'm asking the question, not opining too much.
So that'd be Jeff.
He's just over there. He's just having fun. He's waiting for that.
This is so far out of my wheelhouse. It doesn't even.
All right.
How does maritime law interact with antitrust? Go.
Doesn't. The end.
There we go.
There we go.
All right. Well, great. Wait on that specialization. What was it? Let me go. We've got one more case. I'm just curious how this could turn out. And this is sent in by somebody who actually emails a lot of tips. Thank you very much. Guy named Keith. This is kind of crazy. A woman was confused as being transgender, but she wasn't. And as you read the story itself just seems ridiculous. And I think I'm aging myself. Apparently, she was at the deli buying $40 worth of cannabis, as one would in a deli. And I'm like, wait, what? I again, I'm aging myself, but I'm
going to the wrong delis, man.
Yeah, but
yes.
I'm thinking, where during my lifetime, the state of cannabis and law, where you could be buying cannabis at the deli. So anyway, she was doing it, buying this cannabis, and somehow got into it with the cashier or whatever. And she is suing, alleging that she was pepper sprayed, dragged by her hair, and thrown out on the sidewalk when they had a confrontation. And I guess during the transaction, the cashier selling the weed became upset by a miscommunication over prices, she said. The employee threatened to call the cops before hurling a transphobic smear, she told the Daily News. She claims, she said, call the cops, I just want my money back. And then I heard him call me a transvestite. I'm like, transvestite, I'm a whole female, I have lady parts. I guess what caused the confusion is that she had an Apple Watch with a rainbow print wristband during the encounter. But after asking for the money back, she claims that the guy pepper sprayed her in the face, ran around the counter, and grabbed her by her long hair. There was cell phone footage obtained by the newspaper showing this, her being dragged out of the store. But what is very weird is New York Police Department confirms Adams reported the incident with the same details she gave the media, according to the local news and the Daily News, but no arrests have been made.
That tells you something led up to the, can I have my money back? There was something, there's something we're not being told about that story.
Yeah. Because I'm sorry, I'm just very confused. How in the world here we go. She said the officers responded 4 hours later, appearing to know the attacker and referred to him as Mr. 4th of July.
Oh my gosh. There's some things we don't want to know.
What's up, Mr. 4th of July?
Yeah, I'm completely confused by the whole case. I think that
he's got the guns of independence.
Yeah.
Maybe he has an explosive temper.
Or maybe that was just the body count for that day.
I don't know. Anyway, that's all the cases I had pulled up. Is there? Oh, somebody in the chat asked about this case. Have we discussed the Oklahoma judge that has a petition for removal filed against her by the Chief Justice of the State Supreme Court for judicial misconduct?
I don't know. I know that, Oklahoma's got a lot of cool stuff happening. And MG Law, I think, is in Oklahoma. And, they have that Glossop case, which is a really hairy death penalty case. That's basically one that of possible actual innocence. And the guy's been sentenced to walk to the death chamber 3 times and keeps getting, it's a very controversial case. And I know that he's handling that. And then obviously, if you want to do, if you're in Oklahoma or you have, he's there on the ground, and that's the guy to go to for Oklahoma stuff. So on MG Law, check out his channel for that sort of stuff. I have not heard about that, but
yeah, and MG Law, reach out to me on Twitter. Maybe come on the panel sometime. I definitely, I want to be wide open to as many different voices and ideas as possible. So then, go and wrap things up. Steve Gosney, what do you have going? You sent me something in the private chat. What's up here?
Did I? What was that?
Law of self-defense.
Well, you go ahead and say that's what is going on there.
Okay, is this you?
Well, no. This is Andrew Branca is going to be auctioning off the T-shirt. So we need to make sure that tonight on Rekida's show. So that's kind of the T-shirt, which he got from the public defender's office. The public defender's office sent him a nasty gram, and it's been quite the kerfuffle. So he's monetizing the hate, and I'm all for it. No, what I'm doing is tonight at 8:00, I will be doing a pre-Jeff Legal Vices stream wherein I will talk about. I have some ideas because everybody knows me as the anti-death penalty guy. But I'm also pro use of deadly defensive force, as well as, if you read death penalty debates, talking about war and justifying, use of deadly force in war. And so I want to talk about that distinction and about how one can be pro or anti-death penalty, pro-life, but also support deadly use of force and how that interrelates with the use of force context. So I have some ideas on that I'm going to talk about at 8 o'clock, as well as...
Is it as simple as the idea that the threat is now versus retribution?
Well, you got to tune in and find out. And then the next, I'm also going to talk about ammunition, suggestions for ammunition stockpiling for us preppers. And then we will,
like a loaded issue.
We will dump it over to Jeff and Legal Vices, who's having his F-It Friday stream, and I can't wait. I'm very excited about it. So I'll hand it off to Jeff right now.
7.5 hours, chill stream. Be there, be square.
Okay. Perfect. Jeff is tired. He needs to go to bed. Kurt, what do you have coming up?
Well, I'm actually shifting formats on my channel. So I'm going to I'm experimenting with a scripted style. So I think I've done one scripted video previously on my channel. On my 2500, it's been scripted. But next week, I'm going to try scripted videos, edited videos. So with more heavy editing. So Monday, I have a video dealing with Hillary Clinton saying that she wants to have all the right-wing MAGA people deprogrammed. So I already have that video edited, ready to go. On Wednesday of next week, I'm going to try to have a video dealing with the UAW strike, a little bit of a retrospective on that issue. And then I'm also looking at doing one probably on the Israeli war, probably for next Friday, trying to like sum up my thoughts there a little bit. So that's some of the stuff that's going on my channel. Thursday nights, I'm trying to experiment with a live stream in the same style and spirit of Law and Lumber's Friday Night Frenzy or Ian Runkle's Monday. We're doing a Thursday night law review. Incidentally, any of you guys are welcome to join me. Thursday nights, 7 p.m. Eastern time, or is it Central time? Yeah, 8 p.m. Eastern, 7 p.m. Central. We'll do a little law review, try to keep it fun, casual, not too much, just hang out, be fun. So that's some of the stuff coming up on my channel. So check out my channel next week and let me know if you like the direction we're going.
And are you saying that you are going to be announcing on your channel that you have information that could lead to the arrest of Hillary Clinton?
Stay tuned next Thursday.
Maybe.
I want to live.
It's nice telling you, Kurt.
I want to live.
I keep doing that to Jeff. I don't mean to. It's just the way the squares have worked out. Joe isn't here for me to kick off, but anybody's interested, we're doing America's Untold Stories Freeform Friday today. We did not do a show on Tuesday out of respect of what was going on in the Middle East. We'll be talking about tonight. It probably won't be a casual episode. Let's just say that there are relatives of different Palestinian authorities that are tied into certain World War II figures, and we're just going to probably break down a little bit of history, which we do on the channel. Folks will, I'm sure, enjoy that. Nobody seems to have an opinion one way or another on what's happening in the Middle East. But if you
I have many opinions.
If you like this kind of show, please consider subscribing so I don't have to keep burying poor Jeff in the corner. And I will see you.
My parents did it most of my life.
Next Friday.